ఓకే. థ్యాంక్ యూ. సో ఇవాళ మనకి ఇంపార్టెంట్ ఫస్ట్ స్పెల్‌లో ఉన్నటువంటి వన్ ఆఫ్ ది ఇంపార్టెంట్ టాపిక్ ఈస్ దట్ ది పవర్స్ అండ్ ఫంక్షన్స్ ఆఫ్ జ్యుడిషియరీ. సో ఇందులో ఫ్రమ్ దిస్ we can expect some 5 to 6 questions from especially from the judiciary, independence of judiciary and the judicial review. These two are important. What is judicial review and the autonomy of the judiciary? So, in this regard, we have to move on to the first of all, we have to understand the powers and functions of the judiciary. That means the nature of the judiciary. So, we can understand the judiciary, what is the purpose of the judiciary, and what are the main functions. So, the purpose of the judiciary is to interpret the law, to review the law. That is the main motto of the judiciary. That's why the concept of judicial review. So this especially we say that the judiciary is one of the branch of government. That means we have the three organs of the government, that is legislature, or otherwise it will be known as the parliament, and another one is the executive or a government or judiciary. These are three organs of the government. These are the three organs very very necessary for the effective functioning of the administration and for the redressal of the grievances of the people. These three are very important. Among them, this judiciary is very important because the parliament or government may misuse the powers to check that the judiciary effective functioning is very important. That's why this is one of the executive branch of that organ of the state, that is the legislature, executive and judiciary. Among them, this is third one, and this is very important one, and its primary duty is to interpret the law and the apply law and ensure justice served. That is the important. If you don't have the judiciary system, we cannot get the constitutional, and the constitution cannot give the fundamental rights without that. Even though the constitution is giving the fundamental rights, whether they are enforced or not, whether they are implementing or not, whether they are implementing in effective way or not, this all will be viewed by the interpreted by the higher judiciary. That is the higher judiciary means the integrated judiciary, Supreme Court, High Court, and district courts and municipal courts. This is in every country we have this kind of judiciary to protect the fundamental. The primary duty of the judiciary is to protect the fundamental rights and to uphold the constitutional spirit. Upholding the constitutional spirit. Judiciary means they cannot arbitrarily implement the law, but their main purpose is to interpret, to act according to the constitution regarding their country is concerned. If you take the India, if you take the America, everywhere where judiciary uh, follow their constitution, what were mentioned in mentioned in the constitution, or whatever the things which were incorporated in their constitution, that will be truly followed and upheld by the judiciary. That's why the judiciary is considered as the guardian of the constitution and the guardian of the fundamental rights. In modern days, it is very important because of the functioning, the nature of the executive. The government always try to misuse the powers, or they always try to exceed their jurisdiction while exercising their administrative function. To check that the judiciary, the independent of judiciary, is also very important. So the some of the important functions we can interpret here. We can see that the first important is the interpretation of law, and then we have the judicial review. This is very important. We can expect one or two questions from the judicial review. Judicial review, judiciary has the power. We can look at the meaning of the judiciary has the power to review laws, executive acts, and government policies to ensure they are constitutional. That is the validity. The validity of the law will be checked by the judiciary. That is very, very important. That's why judicial review, it considers the whether it is having the constitutional validity of the constitution. Whether that means whether they are following the constitutional spirit or not. If they are violating, then it will be struck down. It is called ultra vires. అంటే వాటిని చెల్లనేరవనే అధికారం న్యాయస్థానాలకు ఇవ్వబడుతుంది. ఎప్పుడైతే ప్రభుత్వ చర్యలు గాని, విధానాలు గాని రాజ్యాంగానికి లోబడి కాకుండా, రాజ్యాంగానికి వ్యతిరేకంగా గాని, రాజ్యాంగానికి వెలుపలికి వెళ్లి ప్రవర్తించినప్పుడు వాటిని చెల్లదని కొట్టివేసే అధికారం దాన్ని ఏమంటాం? న్యాయ సమీక్ష అధికారం తెలుగులో. So it is called judicial review because if you don't have the constitutional guarantee ensured by the Indian constitution or any constitution, it will be considered as a judicial review. This is very, very important. And if your law action is found conflict with the constitution, then the judiciary can declare it unconstitutional, and it is a cornerstone of maintaining the balance of power. The judiciary's main function is that to restore this peace and the balance of power. That balance of power means, according to the constitution, the three organs of the state, they should follow and they should act accordingly the constitution. Whatever the constitution given the functions, they should be followed. They should not interpret, they should not go against that constitution. That is very, very important. That's why the judicial review concept is very, very important. And up late we will hear the word judicial activism. Judicial activism is also one of the important concept. Judicial activism means the judiciary to be very active, being very active. And under judicial activism, some of the cases may be summately taking. Summato means voluntary. Some, for example, if any issue came in the newspaper, that newspaper news will be taken by the judiciary as a summato, and based on that newspaper article or news, they can issue that directions to certain officials or the government. It is called as judicial activism. That means that the judicial activism encourages the judiciary creative or important play. That means they are very active and dynamic in nature in the contemporary issues are concerned. That's why the judicial review and judicial activism also very, very important. The summato power means they can take voluntarily any case. They will take up any case. That is called judicial activism. Summato power. Nobody need to mention and file the case, but they themselves, the judiciary can take up. And the interpretation of the law, another one important feature is the interpretation of law. That this is the main purpose of the judiciary. The rationale behind creation of the judiciary is that interpretation of the law, protection of the constitution, and protection of the fundamental rights. These are the main purpose of the judiciary, to restore the balance in the society. And adjudication of the disputes. The judiciary settles a dispute between the organization and the states and the central state. These all disputes solved by the judiciary. The courts are empowered to resolve civil, criminal, and constitutional cases. We, on the basis of the nature of the cases, we can be classified into the civil cases, criminal cases, and constitutional cases. That means constitutional related cases. And issues of the ordinance. The court can issue the orders and writs like habeas corpus, some of the unlawful detention, mandamus, and prohibition, certiorari, like this. These are the writs. That means the writ means it is a order, or we can say when the fundamental rights are violated of anybody, the person who got they are infected, they can approach the judiciary. Then the judiciary issues for example, habeas corpus. If anybody detained unlawful activity, then on behalf of that person, their friends or their family members or then anybody can approach the higher judiciary. Then the judiciary issues habeas corpus. The writ is called habeas corpus. That means within the 24 hours of stipulated period of time, the body should be produced in the court physically. That means habeas means have the body physically and present in the court within the stipulated point of time. That is 24 hours of time. So in such this kind of writs protects the fundamental rights, and it also prevents the misuse of power. That means covenanto. Sometimes it may issue the covenanto. Covenanto means by what authority you are exercising that power. This kind of writs will be issued by to the public officials when they violate their the duties that are existing. They perform, if they perform beyond their duties, this kind of duty writs may be issued by the judiciary. The main purpose is to protect the common man, to protect their rights. That is the main purpose of the writs. This is the only writ issuing of authority will have given to the judiciary by the Indian constitution or their concerned constitution. And protection of fundamental right is also very, very important. I told that this judiciary is the ensuring the fundamental rights. That's why the fundamental rights in the feature is that they are justiciable. That means the aggrieved person, they can approach the rights. That means they can approach the courts. Then only that is called justiciable. If my right to life under Article 21, if it is violated, then I can directly approach the judiciary. That means the judiciary ensures my fundamental right, that is justiciable. And if you know that the directive principle of state policy, in that case they are not justiciable. If the government having the sufficient money or funds, then only they will be implemented. For that we cannot enter the cannot knock the doors of the judiciary. This scheme is not implementing. Why? Because they are not justiciable. They are like checks in the bank. If the money is available, they can be disputed, dispatched. Otherwise, they simply they will be there on the paper. That is the difference between the fundamental rights as well as the directive principle of states. That's why the fundamental rights are justiciable. That means they are guaranteed by the constitution and they are interpreted by the protected by the judiciary. This is the one important observation we have to need to mention. Some question may come, which of the following is justiciable? That means fundamental rights and independence of judiciary and impartiality. This is also one of the important. It protects it creates a common man faith in judiciary, as well as it gives the confidence and the fair functioning and behaving like a impartial. The judiciary should not have any bias while taking the decisions. That judiciary means all equal for all. That's why we have that concept, rule of law. The rule of law, what the law says, that all are equal in the eyes of law. That means the judiciaries should treat everyone equally, if until and unless they commit their crime or anything. Otherwise, they all are given equal treatment. No, there is no differential treatment. That is the main meaning of that. These are the some of the features so far we have discussed. So we move on to the some of the questions. How they appear, they may appear. That is the first one is what is the primary role of judiciary? We know that the primary role of judiciary is to interpret and apply the laws. That is the main motto of the judiciary. And what is the primary role, the primary motto of the parliament? That means making the law. And what is the primary motto of the government or the executive? To implement the policies, to execute the policies. So here what I am telling, that the primary role of the judiciary is to interpret and apply the laws. Answer is C. And the second one, which one of the following is not a function of the judiciary? That means law making function is not the main function of the judiciary. It is the law making function is solely belongs to the parliament or the state legislations. The law making power is given to the legislature or the parliament by the Indian constitution. Law implementing, law interpretation is giving that is the main function of the judiciary, not the law making function. And next one is the power, which powers allowed the judiciary to declare a law unconstitutional. When the which power means the judicial review. Under the judicial review, the judiciary has given the power to declare unconstitutional if they are not following the constitutional norms. That is very, very important. That's why the judicial review, the concept of judicial review is very, very important. We definitely expect one or two questions from judicial review especially. And what is the function of the judicial review? It says that to check if the government actions are not constitutional. To check if the government actions are not constitutional. That is the main purpose of the judicial review. The judicial review sees the constitutionality of the law or the policies. That is very important. Okay. Next one. The fifth one is that which of the following writ is issued to the protect an individual from the unlawful detention? That is the habeas corpus. If anybody unlawfully he was detained, he was arrested, then the judiciary intervene, issue the habeas corpus. Habeas corpus literal meaning is that have produced the body, physical produce of the body, production of the to produce the body in the court, to have the body in the court present. That means the physical presentation of the body in the court premises. అంటే ఒక వ్యక్తిని భౌతికంగా కోర్టు ఎదుట హాజరుపరచమని చెప్పేటువంటి అధికారాన్ని మనం ఏమంటాం? హేబియస్ కార్పస్. And the next question is that what is the term for a court's authority to hear or decide a case? That is the jurisdiction. Jurisdiction is very important. As I said that each organ of the government, they should act according to their jurisdiction. Their jurisdiction means what is their purview, to what extent power they have been issued ensured by the constitution. That is called jurisdiction. And the next one, the seventh one is says that the power of judicial review was established in which landmark case in United States? It many a time this question definitely comes. That is the Marbury versus Madison. Marbury versus Madison case. This is the first case through which the landmark judgment was came in America. The judicial review was established through this case. Madison was Marbury versus Madison. You have to remember this case. This is very important. Many a time question will appear. The judicial review was born. The concept was born from this case onwards only. So we have to remember that one. And next one, which function of the judiciary ensures the laws apply equally to everyone? That is the ensuring a rule of law. As I mentioned that the rule of law is very, very important. The rule of law treats everyone equally. There is no differential treatment until or unless they indulge in a conviction. వాళ్ళు ఒక చట్టం ఒక నేరంలో ఇన్వాల్వ్ అయితే తప్ప వాళ్ళకి అందరికి కూడా పౌరులందరికీ కూడా సమానమైన ట్రీట్మెంటే ఇవ్వడం అనేది జరుగుతుంది. And the next one, which of the following is a primary power of the judiciary? That is the interpretation of law, interpreting the laws. చట్టాలను అనువర్తించడం, వాటిని వ్యాఖ్యానించడం జుడిషియరీ యొక్క ప్రధానమైనటువంటి విధి అనేది మనం ఇక్కడ గుర్తుపెట్టుకోవాలి. నెక్స్ట్ వన్, the judicial independence is essential for which one of the following reasons. అంటే ఈ judicial, why we need the independence of the judiciary means to maintain a balance of power in the society. If we don't have the independence, they cannot act like a impartial person. They cannot act, they may, if they don't have independence, the judiciary or the executive or the legislature may intervene into their functioning, or into their domaining of the functioning. Then their functioning may be polluted, they may be corrupted. So that's why, and their hands may be influenced by the executive. That's why the constitution has ensured that the judicial independence. That means they have their own independence. They do not need to get the support from other or influenced by the executive or internal or external forces. That is called the independence of judiciary. And it also implies that the tenure, the security of the tenure is more important here. If anybody try to remove the judges, it is not an easy. The both houses of parliament should initiate. One house should initiate and one should accept. Then only they will be removed by the president of India in our country is concerned. India is concerned. That is a very difficult task. That is not. That's why they have given the independence. And the process of resolving disputes outside court is known as, it is known as the alternative dispute resolution, ADR. This may be a they may ask like that, what is the alternative dispute resolution? That is outside this resolution takes outside from the formal court of judiciary system. And what does judicial activism refers to? In the beginning, I showed that the judges making decisions based on personal or policy reviews on their own. That means on their own means here judicial activism basis on the personal or political reviews. That means any policy is hurting the people. Some for example, if hydra is going on in our Telangana, if somebody has been deeply losing their property, but they are unable to make a case or complaint in the high court, then but that scene was appeared in the newspaper, then the judiciary will itself can take that case as a sumoto, and they can issue the writs to the hydra administrative. That is called the judicial activism. That means the court themselves they can act even though the official complaint is not received by some party or some any other person. This is called judicial review. That means judicial activism. And which one of the following is example of a writ issued by the courts to prevent a lower court acting beyond its jurisdiction? That means prohibition order. It is the order given by higher court to the lower court. ప్రొహిబిషన్ దట్ మీన్స్ మేము మీకు పరిమితి ఇవ్వడం లేదు, నిషేధిస్తున్నాము అనేది పై స్థాయి కోర్టులు కింది స్థాయి కోర్టులకు ఇచ్చేటువంటి ఆజ్ఞ, దాన్ని మనం రిటర్న్ చెప్పడం జరుగుతుంది. And the power of judicial review ensures that the judiciary can ensure laws do not violate the constitution. The judicial review, the main motto of the judicial review is that to decide the constitutionality, the validity of the law. That's why it ensures the law do not violate the constitution. Even though the parliament making many laws, if they are violating the Indian constitution, the spirit of Indian constitution, then the judiciary will struck down that. That is a main motto of the judicial review. And next one is that Which one of the seven? Okay. Which one of the judiciary ensure that law apply to equally everyone? Oh, it already over. Next, which is a primary power of the judiciary? Interpretation law and just right. Which writ issued to court prevent corruption from acting beyond its jurisdiction, a prohibition. Now, the judiciary is not part of which branch of government, that is judicial branch. It comes under judicial branch. The executive, legislation, judiciary. These are the three organs of the government, or they are three branches. These were classified based on their nature, functioning of their nature. That's why Parliament is making laws, executive is implementing the policies, and the judiciary is validating the constitution. That means interpreting the laws. So in this way, and what is the concept of stare diseases? It is a principle of adhering to the precedents. That means పూర్వ కేసులను అనుసరించడం అనే దాని అర్థంలో ఇక్కడ మనం ఉపయోగించడం జరుగుతుంది. అండ్ విచ్ వన్ ఆఫ్ ద ఫాలోయింగ్ నాట్ ఎ పవర్ ఆఫ్ ది జుడిషియరీ? ద మేకింగ్ లాస్ ఇస్ నాట్ ద పవర్ ఆఫ్ ది జుడిషియరీ. అండ్ వాట్ డస్ ది జుడిషియరీ డూ వెన్ ఇట్ డిక్లేర్స్ ఏ లా ఆర్ అన్కాన్స్టిట్యూషనల్? కాన్స్టిట్యూషనల్ కానప్పుడు ఏం చేస్తుంది జుడిషియరీ? ఇట్ నల్లిఫైస్ ది లా. దట్ మీన్స్ ఇట్ ఇస్ స్ట్రక్ డౌన్. ఇట్ విల్ స్ట్రక్ డౌన్ ది లా ఇఫ్ ఇట్ ఇస్ నాట్ అకార్డింగ్ టు ది కాన్స్టిట్యూషన్. And the next one, what is the main purpose of the judicial independence? Judicial independence is that the main purpose to avoid the influence from the executive and the legislature. These are the executive, that means the government or the parliament, they should not influence the judiciary. That's why they have given the free hand. That is called independence of judiciary. This is very, very, very important. And which one of the following an example of the judicial preventing the abuse of power by the states? That is reviewing laws that violate human rights. మానవ హక్కుల ఉల్లంఘన జరిగినప్పుడు వాటిని పర్యవేక్షించేటువంటి అధికారము న్యాయస్థానాలకు ఇవ్వబడింది. పర్యవేక్షించడం అంటే రాజ్యాంగబద్ధతను, చట్టబద్ధతను నిర్దేశించడం, వాటిని పునః సమీక్ష చేసేటువంటి అధికారం జుడిషియరీకి ఇవ్వబడుతుంది. And which one of the following judiciary revolves disputes between the citizens and the states? The adjudication of disputes. It will solve by the adjudication of disputes. So these are the some of the functions, questions which belongs to the judiciary and the powers and function. Now we will move on to the independence of judiciary. The independence already I have explained briefly. This is the main purpose to maintain a fair and balanced legal system where justice can be delivered without fear or favor or bias. That is the main meaning of the independence of judiciary. They can deliver justice without fear, favor or bias. That is the meaning of independence of the judiciary. So we can see some questions. What is the term of judicial independence? Primarily refers to the judges. Judges should be free from influence or pressure from the executive or legislature. That means వాళ్ళు ప్రభుత్వం నుండి కానీ పార్లమెంట్ నుండి కానీ ఎలాంటి ప్రలోభాలకు లోను కాకుండా సొంతంగా తమ విధులను తాము నిర్వర్తించే విధానాన్ని మనం ఏమంటామంటే న్యాయశాఖ స్వయం ప్రతిపత్తి. And which of the following ensures a judicial independence? That is the judges have secure tenure and only can be removed from the misconduct. This is ensures the independence of judiciary. And the security, it gives the tenure of the security, and they only be removed only when they have the misconduct. And why is financial independence important for the judiciary? To prevent corruption, to ensure that decisions are not influenced by the executive or the legislature. That's why they need the financial independence. That means they should not dependent upon the executive or parliament. And which body usually handles the removal of the judges that should ensure the independence? That is the an independent judicial commission is required. And which one of the following threatens to judicial independence? That means the public opinion influence and influential court decisions. These are the important which influence threatens to the independence of the judiciary. And next one, in a system which judicial independence, what is the usual method of selecting judges? That means they are based on merits through an independent judicial body. They should not be selected from the back door. They always should be selected on the basis of the merit and the principle of seniority. And which one of the following is not a safeguarding for judicial independence? That is, the judge's salary is being determined by the executive. This is not a it not in ensuring the independence of the judiciary. Their salaries should be paid from the consolidated fund of India. You know that వాళ్ళ సాలరీస్ అన్ని కూడా కాన్సోలిడేటెడ్ ఫండ్ ఆఫ్ ఇండియా నుండి ఇవ్వబడతాయి. ఇప్పుడు జడ్జెస్, హైకోర్టు, సుప్రీంకోర్టు జడ్జెస్ అన్ని కూడా అగంతుక నిధి నుండి చెల్లించబడతాయి. ఎందుకంటే దే షుడ్ నాట్ డిపెండ్ అపాన్ ది ఎనీ ఎగ్జిక్యూటివ్ ఆర్డర్స్ ఆర్ దేర్ blessings. So that's why they have the their salaries are being paid through the consolidated fund of India. And which one of the following is a consequence of law of judicial independence? That is, the possible corruption and biased decisions will be prevented. And which one of the following is best describes the independence of judicial independence? That is, it ensures that decisions are made fairly, free from political influence. That is the main importance of the judicial review. And in which of the following countries the judicial independence protected by securing life tenure for judges? It is in United States of America. అమెరికాలో జడ్జిల యొక్క జీతభత్యాలు కానీ వాటిని ఎలా సేఫ్ గార్డ్ అవుతుందంటే సెక్యూరింగ్ లైఫ్ టెన్యూర్. అంటే వాళ్ళకి జీవితకాలం ఏముంటుందంటే భద్రత అనేది ఉంటుంది, పదవి భద్రత అనేది ఉంటుంది. కాబట్టి అమెరికాలో వాళ్ళకి అది ఇవ్వడం అనేది జరుగుతుంది, మనం చూడొచ్చు. అండ్ the next important one is the concept is judicial review. It is very very important. As I say that the law will be interviewed. The law validity of the law, the validity of the case, the validity of the policy of the executive will be viewed by the judiciary, interpreted by the constitution, according to the constitution, by the law. That is called judicial review. So what does the judicial review primarily allows the judiciary to do? The declares law unconstitutional. If anything it goes against the constitution, under the judicial review power, the judiciary will declare unconstitutional. And which landmark can be in the United States established the power of judicial review? That is already we discussed that Marbury versus Madison case. This is very important case which was laid the foundation for the judicial review in the entire judicial process. And the judicial review allows courts to evaluate the constitutionality of law, executive orders, and government actions. These three will be given under the constitution to evaluate the constitutionality. And next, which of the following is not a key aspect of judicial review? That is, making laws that align with the public opinion. It is not their aspect of judicial review. And judicial review is a mechanism that ensures the government actions comply with the constitutional. That means whatever the constitution doing, whatever the government policy or the actions that they are doing, they should align with the constitution. That means they should go according to the constitution. Then only they will be validated. They will be protected by the judiciary. Otherwise, they will be declared as a null and void. And which one of the following is an example of judicial review? It is a court declaring law unconstitutional because it violates the human rights. Then only it will be viewed as a seriously. And the judicial review is the most commonly associated with the which constitutional principle? That is the separation of powers. As I know that in the previously I displayed that the Montesquieu, the writer who written one book, the spirit of law. In that book, he mentioned that the separation of powers means the powers between the parliament, government, that is the legislature, executive, and judiciary. They should be separated, and they should act independently. There is one organ of the government should not intervene into the other domain of functioning of the other organ. For example, parliament